Hi everyone and welcome to this week's event, Referenda in Review. This is part one of a four-part series in which we'll be discussing all things to do with referenda, from repeal of the 8th Amendment to marriage equality to Irish nationality and the 27th Amendment. Today we'll be discussing some possible future referenda topics, and we're so excited to be joined by a great lineup of speakers, including Anne Conlon. She's a barrister and a committee member of the Irish Women's Lawyers Association. She'll be discussing Article 41.2 of the Irish Constitution, which outlines the women's place in the home. We're also joined by Ben Kelly. He's the Vice-Chairperson of VICA, that's Votes for Irish Citizens Abroad, and he'll be discussing the extending of the right to vote in Irish presidential elections to citizens living abroad. And we're also joined by Sinead McGarrigle. She is a solicitor at the Mercy Law Centre and she'll be discussing the right to housing. We really hope you enjoyed this event and the forthcoming events in this series, and thank you for watching.
My name is Anne Conlon. I'm a barrister, and it's my pleasure today to present to you on behalf of the Irish Women's Lawyers Association on Article 41.2 of the Constitution. The Irish Women's Lawyers have been doing quite a bit of work on Article 41.2. Initially, we did a significant piece of research, and we've done a number of other events and podcasts since then. I'll talk about those a little later. Apologies. So just to talk about Article 41, it's just to read through it. Section 1, the state recognises that family is the natural, primary and fundamental unit group of society and as a moral institution possessing inalienable and imprescribable rights, antecedent and superior to all positive law. And then 2, the state therefore guarantees to protect the family in its constitutional authority as the necessary basis of social order and as indispensable to the welfare of the nation and the state. And 41.2.1, in particular, the state recognises that by her life within the home, woman gives to the state a support without which the common good cannot be achieved. And 2.2, the state shall therefore endeavour to ensure that mothers shall not be obliged by economic necessity to engage in labour to the neglect of their duties in the home. So I'm a little bit limited in time, and I'm just going to give you a very quick synopsis of the history. There's a very extensive history in the research paper that's written by the written for the Irish Women's Lawyers Association, but basically just by way of commentary on the 1937 Constitution, of which this Article 41.2 first comes into the Irish legal framework. And the Women Graduates Association at the time described the Constitution as sinister and aggressive. Hannah Sheehy Skeffington claimed that the new Constitution was based on a fascist model in which women would be relegated to permanent inferiority. And of all the articles that were in the Constitution, it arguably caused the most controversy both inside and outside the Dáil where it was first published, when it was first published. And De Valera, who was leading the government at the time, was at a complete loss to understand women's objections to it. And there is a lot of very, very interesting history about that whole period. And even indeed what was going on in Europe at the time that might have contributed to the thinking that was going on in Ireland with regard to the role of women. When it comes to case law on the matter, there has been, Dr. Liam Thornton of UCD has looked at the case law, and he's determined that Article 41.2 has arisen in approximately no more certainly than 25 cases. In about 15 of those, it was just by way of a passing reference with no real significant engagement with the article, but it was considered in approximately 10 cases. Interestingly, and again, there's analysis of the case law in the paper, some of the cases it was used to discriminate against women. Sometimes it was used to discriminate against men. And it was, I suppose you could say, it was sort of used willy-nilly, whatever way, particularly the state wanted to avail of it. In one interesting case, Hyland versus the Minister for Social Welfare, Mr. Justice Barrington, in giving judgment, described Article 41.2 as a duty of imperfect obligation. And what we begin to see is that the problem lies with the word endeavour. So where the where it says in Article 41.2.2 that the state shall endeavour to ensure that women shall not be obliged by economic necessity to engage in labour to neglect of their duties in the home. I mean, I think there are a couple of things that one might at first glance think were applicable to that. Firstly, that a woman wouldn't by economic necessity have to leave the home, i.e. she'd be supported to stay in it. There might even be an argument to say that she might be entitled to a home. The problem with the wording is that the word endeavour is in there, and once all that is required is that the state will try to provide, economic support to a woman, there's no way that the courts can enforce that, and therefore it's a duty of imperfect obligation, and that imperfect obligation was actually put to De Valera at the time of the passing, but he just saw it as the role of a government to determine how it would provide that support. So the main case I'm going to talk about is a case called BL versus ML. Now, this was a case where Miss Justice Catherine McGuinness, as she is now, was senior counsel at the time, and she was supported by her junior counsel, the now Miss Justice Carmel Stewart of the High Court. And this case involved a plaintiff wife who was seeking a declaration that she should have a beneficial interest in the family home in circumstances where she'd made a contribution in money and money's worth to the purchase price of the home. And the marriage had broken down, the couple were separating, and she argued that she looked after the home and that she looked after the children and she provided occasional assistance to her husband. And ultimately what Mr. Justice Barr decided in the High Court was that Article 41.2 conferred a property right on a woman through the assessment of her work in the home, though this right only extended to the family dwelling and not to and its contents, but not to any property of her husband above and beyond that house. So the defendant appealed that decision to the Supreme Court, and a 5-judge Supreme Court unanimously overturned that decision. Now, Ms. Justice, recently interviewed by Dr. Laura Cahalan, Justice Catherine McGuinness said that they felt that it was worth having a go to see if Article 41.2 could be relied upon, and when they encountered their brave client, as I say, they decided to have a go. But in effect, that was the death knell of Article 41.2 in terms of a woman being able to rely on it. It in effect became meaningless thereafter. You couldn't go into court and say, I seek to rely on my rights, here it is. It just had no effect going forward. What has happened since? And I suppose what's happened since is that there have been 10 reports over many years, both domestic and international, including 2 United Nations reports. The sort of more recent of these were the Convention on the Constitution in 2013, which suggested amending the article, making gender neutral, including carers, so in effect taking out mothers, and that the state should provide some reasonable level of support. That report was given to a task force at the Department of Justice, and they made further recommendations. And then what sort of brought it to the fore recently is that the Programme for a Partnership Government 2016 committed to holding a referendum on the article. Now, it was due to be held with the referendum that was held on blasphemy, but because of, I suppose, there was no certainty about what was going to be proposed, it was the 38th Amendment of the Constitution, Role of Women Bill, was passed back to the Oireachtas Joint Committee for further legislative scrutiny, and that was 2018. So 9 groups presented to that committee, and their submissions can basically be broken down into sort of 3 headings. The first group said repeal simpliciter, take it out. One of the main reasons being that there are no unintended consequences if you just simply remove it. Second group said amend some sort of symbolic recognition of carers, or actually put in concrete socioeconomic rights. And I've set out the various groups that made the different submissions. The third group said amend Article 41.2 and add new provision to Article 45. Now, the significance of that is that Article 45 it commences with the wording: the principles of social policy set forth in this article are intended for the general guidance of the Oireachtas. And what that means is Article 45 cannot be enforced in court, so you can't go in and rely on it in court. And so in a way, I suppose it just sets out aspirations on the part of society. And that was supported by the Minister for Justice and Dr. Cahir Lattin. And I suppose they put that forward in circumstances where deletion was not. They had also supported the complete deletion of it. So out of that came two options out of that committee. The first one was to replace the article with alternative provisions in terms of home, family life carers, but no allocation of public funds. And the second was that there should be more public engagement would be recommended, looking at broader discussion of the role of care work and decisions about whether putting carers in, whether it should be symbolic or whether there should be a concrete socioeconomic rights given. So where have we come to with it? Well, where we come to is earlier this year in February, the Citizens Assembly met and they were presented with the report of the committee and asked to look at Article 41.2. And they met in February. They were due to meet again in March, but for COVID reasons, obviously that hasn't occurred. And they haven't come to a final conclusion, but just in the initial discussion, it was noted that 88% favoured deletion, but 98% wanted to replace it with gender neutral text to include other carers in the home other than women, which had been mothers, and 62% of the Assembly felt that any reference to carers should include carers who worked outside the home. So where does that leave us from here? Well, the Citizens Assembly is going to make recommendations. There's a strong argument to be said that there should be two debates about this. One should be, do we take it out? A yes or no answer. And then I think that, arguably, and the Women's Lawyers Association would really support this, that it should be taken out. It hasn't been able to be relied on in law and has served no purpose and arguably may have been, a bulwark to women advancing their rights over the years. However, there is undoubtedly a second debate as to do we want to put something in, and that is where the debate is at, I think, at the moment. That's my 12 minutes. I'm going to say to you that the Irish Women's Lawyers Association on their website have a podcast, a recorded seminar and a copy of a Law Society Gazette article on this topic. There's also a research paper available, a 10,000 word, very extensive piece of research, which I can forward to anybody who emails me. I'm very happy to do that. Lastly, can I say to you, consider joining the Irish Women's Lawyers Association. It's a very active and interested group of lawyers advancing the cause of women solicitors and barristers throughout the country and supporting one another. And I myself have been a member now for 5 years and I thoroughly recommend it. My contact details are there. Please feel free to ring me or email me. I'm very happy to take any calls or queries. Thank you.
Hi everyone, my name is Sinead McGarrigle and I'm a solicitor at the Mercy Law Resource Centre. The Mercy Law Resource Centre is an independent law centre and registered charity that was established in 2009 and is based in the Liberties in Dublin 8. Our core service is the provision of legal advice and legal representation to people who are homeless or at risk of becoming homeless, mainly in relation to housing matters. Some of the issues that arise and that we deal with on a daily basis include accessing homeless accommodation. So that could be something as basic as having somewhere safe to stay for the night, or it could be helping people seek appropriate accommodation where they are in highly unsuitable accommodation, whether that's emergency accommodation they need or long-term housing. We often see people, regularly families, who have been in entirely unsuitable emergency accommodation for a really long period of time, often many years. We also help people with evictions from social housing. And then in general, we try to ensure that homeless people are treated by local authorities in accordance with fair procedures. Over 80% of our clients are of ethnic minority background, which highlights the additional hurdles that this group faces when accessing services. So they may face language barriers, there might be a lack of knowledge around rights and procedures, they could face bias, or important cultural differences may not be respected by local authorities. Having gained first-hand experience of the extreme hardship faced by people in this country every day in relation to housing, Mercy Law has for a long time placed the right to housing at the centre of our policy work. At present, there are limitations in how far the law can assist in housing cases, especially since the right to housing is not constitutionally protected. For instance, if a local authority refuses to provide a family with emergency accommodation, this can be quite legally difficult to challenge because there is no obligation on the state to provide this. Instead, we must rely on rights on the fringes of the issue, for example, children's rights or the right to fair procedures. As part of our advocacy work for a right to housing, we are a member of a coalition group called Home for Good, which comprises a number of organisations, individuals and academics with an interest in this area. So Focus Ireland are included, Simon Community and also Threshold, along with other organisations. Home for Good is calling for an amendment to the Irish Constitution to recognise a standalone right to housing. For too long, private property rights in the Constitution have been held out by successive governments as acting as a barrier to introducing much needed housing reform, which would benefit the general population. We at Home for Good recognise that the current housing crisis is affecting wide sections of our society beyond those who are immediately homeless. So tenants are spending large portions of their income renting properties with little security of tenure. It is extremely difficult also for young people, particularly students, to secure and afford private rental properties. The lack of supply of housing to cater for the population is also causing house prices to inflate, and purchasing a home is now beyond the reach of many. Home for Good is calling for a right to housing that would place a positive duty on the state to realise the goal of providing access to housing for all. The group proposes wording which would, in the first part, require the state to recognise and vindicate the right of all persons to have access to adequate housing, and in the second part, would include a requirement to realise that right through legislative or other means within its available resources. Our proposed wording is informed by international law, particularly the International Covenant on Economic, Social and Cultural Rights, and the right protected in the South African Constitution under Section 26. After much lobbying, we were delighted to see a commitment from the government in its programme for government during the summer to a referendum on housing, which we understand to mean a referendum on the right to housing. At the beginning of November, Home for Good presented our proposal to the Oireachtas Committee on Housing, which was widely welcomed by its members. Home for Good looks forward to starting work on a referendum campaign to ensure that this proposal is properly understood and to garner the much needed support to ensure that we get the vote we need. In the context of the current pandemic, housing is arguably now more important than ever, as the general population is expected to spend most of their time at home. But what if you don't have a home to call your own, or are living with your entire family in a small hotel room? Inserting a right to housing into the Constitution is not a silver bullet. It will not automatically mean that everyone is entitled to a house, and it will not solve the current housing crisis overnight. However, it would place a positive obligation on the state to take steps to ensure that everyone has access to adequate housing, and it would mean that private property rights would have to be balanced with the right to housing. In particularly egregious cases, it could be relied on in the court to effectively address a significant failure by the state to comply with its constitutional obligation. It would send out the message that we as a nation value the dignity and importance of those around us, and their fundamental rights, and it would provide the government with a strong mandate to act. Thank you so much for inviting us to speak at this series. For more information, please see our website, mercylaw.ie, where you can find 3 reports that we have produced on this topic. Separately, please also see the Home for Good website, which is homeforgood.ie, and register to stay in touch with us and receive updates relating to our work. Thank you.
Hello, my name is Ben Kelly, and I'm the Vice Chair of VICA, Votes for Irish Citizens Abroad. I'd like to thank you for giving me the opportunity to talk to you today about this cause, which we think is really important for our country. Votes for Irish Citizens Abroad is an organisation which was established in 2011, and it's based in London. It's very much linked with that generation who left Ireland after the economic crash, but still felt very invested in life, politics, and social justice back at home. I come from Derry. I've lived in London for 10 years, and I've been involved in VICA for the last 2 years. VICA believes that, as with many other countries around the world, our citizens abroad should have some representation in our national politics. We feel it is the right of those who hold citizenship to have a say in the affairs of their country. And as we know, Irish people abroad have always remained very, very connected to what happens back at home, and that's never been more real than now, when we're all involved with FaceTime and family WhatsApp groups and, yes, even Zoom quizzes. Many of us also hope to return home someday, something which we've seen the pandemic actually accelerating. People want to come back. They want to, if they can work from anywhere, they want to work from home, and they want to be part of determining our shared future together. Consider how important, for example, Irish citizens were in coming home to vote for marriage equality and repeal the 8th, and how important they were at influencing other people and really influencing the arc of those referendums. But they shouldn't have had to fly halfway around the world to have their say. Many other countries and people abroad just get to vote by postal ballot or something similar, and we believe that reform is needed for Ireland too. And luckily, reform is on the horizon. The current new Irish government has committed to holding a referendum on extending voting rights in the presidential elections to Irish citizens outside the state. And that includes citizens in Northern Ireland, as well as those living abroad around the world. This is a great start, and it's where we're currently focusing our efforts at VICA. Let me explain some of the reasons why we think this is such a good idea. Firstly, most countries already have provisions like this. 115 countries actually allow for their citizens to vote from abroad. We think Ireland's a real outlier in this. Even countries like ours, which have huge populations around the world, such as Italy and Mexico, they allow for voting from abroad. I think, and VICA thinks, that we should catch up on this if we want to build a more equal republic. Secondly, it's a great way to reach out to Northern Ireland. I'm from Derry, as you can see. And at the moment, we're looking at this new shared island initiative, which is coming from Dublin. A way of bringing the north closer into the south and working together on shared opportunities. And that works with this. The president represents Irish people in the north as well as the south. Indeed, we've even had a president from the north in Mary McAleese. People like me were so proud to see someone born in Belfast serve as one of our most successful presidents. And as we saw from her presidency, the office can be hugely powerful in terms of bridging relations between North and South, Catholic and Protestant, and Britain and Ireland. We need more of that. But it doesn't make sense that someone from Belfast can run for president and be president, but someone from Belfast can't vote for president. And that's something we think should be fixed. Thirdly, the presidency is a way for Irish people all around the world to feel invested in the nation. The office represents Irish people wherever they are for however long they're there. It's a great thing. And we see that being reflected both ways. You know, you think of Mary Robinson lighting the candle in the window for Irish emigrants. I think of President Higgins, when I see him visiting Irish communities from Liverpool to Sydney, that matters, and people really feel invested and they feel passionate when they see President Higgins, you know, even if he's just walking the dogs, they're thinking, that's my head of state. And, you know, we always talk about valuing and cherishing our citizens around the world, the great things they're doing, how well they represent us, and they do. And for me, there's no better way to extend a hand to them than by including them in the vote for the presidency. Ultimately, if you're an Irish citizen, you should be able to vote for your president, whether you're in Dublin or Derry, Brisbane or Boston. The presidency is a ceremonial office that is increasingly cherished by the nation as a symbol of who we are. And I would feel great pride in getting to vote for the first time in a presidential election come 2025. Throughout history, across every country, extending the franchise has only ever been a positive thing. Increasing participation means greater inclusion, and we want to have a more inclusive Ireland. We know that, we see that, we've seen it in recent referendums and elections. We see it in the discourse that happens, not just in the media, but online. Let's keep that change going with this really positive step. We hope to have the referendum on extending voting rights in the presidential elections as soon as 2021 or more likely 2022. And hopefully between now and then we can garner more support for this change. I hope this has summed the issue up well for you and that you've learned something from what I've had to say. Stay safe, and from everyone at Vika, thank you very much.